Newsfirst Newsline with Faraz Shaukatali.
Well, good evening and welcome to News Zoom. Zoom because of growing concerns about the spread of the COVID-19 pandemic. Now, this evening by Zoom, our guest is the former Director General of the Securities Exchange Commission of Sri Lanka and also a one-time senior advisor to the Ministry of Finance. We've got with us by Zoom on Newsline, Mr. Malik Cader. Very good evening to you, Mr. Cader.
Very good evening to you, Faraz, and nice to be back on the program.
Thank you. Now then, we noticed that in this morning's press, you've written an article expressing some concern about the proposed new SEC bill. What exactly, Mr. Cader, would your concerns be and why are you concerned?
In fact, for us, this particular article, in fact, I wanted it appeared today because on the 18th, this matter will be debated in Parliament. And I hope that the policymakers of this country will take note of some of the concerns which I have expressed. And those concerns are very valid for a good market to operate. I'm saying these things, right, not as an individual, right, Mr. ABC. I'm saying these things with a load of experience which I've had by working for the SEC from 1996 onwards, and also doing certain work where capital markets are concerned, locally and internationally. We have an act which is almost 35 years old. The act has to change. There has to be a paradigm shift. The paradigm shift has to be for the better. We have new complicated financial instruments that we need to work with. So to accommodate that, we need to have a new act. And that is an act that is going before Parliament. And some of those provisions in those acts, I'm sure, right, have been maybe well thought of, and some would not have been thought of. Some of those concerns I'm going to have expressed in that, I shall express again. You know, I think there was a seminar held a couple of months ago, and then there was a former Director General of the SEC, Dr. Aritha Vikramanayake, who went on record to say that this act is a very draconian type of act. And if he has to select between God and being the SEC chairman, he would be the chairman of the SEC because the chairman of the SEC has more power than God. And there's a lot of power that is being given to the SEC through this act, which I think will not be complementary to the market because you're dealing with individuals. You get the wrong person coming in and seated on that seat, which we have seen previously. It is not a good message you're sending to the investing community of this country. That's quite right, you indicated, right? We are trying to do a lot of grand plans and a lot of grand things. We need to find out whether the ground realities for us are in place. Our market is a small market. Our market is a tiny market. Are we ready to absorb these complicated regulatory requirements that are being proposed? These have to be there, but whether this is the time, because the market is in a stage of being developed.
Mr. Cader, can you tell us, give me at least 2 points of contention which worries you the most about the proposed new bill?
Yeah, talking about draconian provisions, yes, to some it might not sound draconian. To some it might sound very academic, right? Nice to have those things in the rule book and the law book, right? For someone who is basically wanting to see that, culprits are simply jailed or, expeditiously fined. There are a couple of provisions, and I think the two provisions that stand out are the freezing provisions that are there, which I think is not very complimentary to a market. If you ask, if some people might agree that you might need to have the freezing provisions, but are you trying to scare away the potential investors and issuers who are coming into the market.
What, Mr. Cader, what do you mean by freezing provisions? Freezing of what? My assets?
Yeah, SEC has, for us, in this particular bill, brought in a provision where they have the power. They will have the power to freeze assets of investors. Not any investor. If an investor is found not guilty, right, is being accused of some kind of a fraud, might be small, might be big, right, might be medium size. The SEC has the power to freeze those assets, which means if you have a bank account, right, your bank account can be frozen, your securities account can be frozen, right? That kind of an ability is there for the SEC. Of course, it says for a period of 7 days, after which they will have to go to courts and get any extensions, if any. Right? One might want to argue and say that they cannot go behind bank accounts. But then if there is someone who is basically, they have been suspected that there is a financial fraud and this man has money, we must see that his money doesn't go anywhere else, so let's freeze it. Then you go to courts within 7 days, and courts, it's like handing over a nice baton, right, to the to the judge. And obviously, when the regulator says so, the judge would certainly give an extension. And all these things will happen fairly ex parte in the system. What I want to emphasize here is, do you need to have this in the rule book? Do you need to have this in the SEC Act? This can anyway be done. This can anyway be done under the normal laws of the land. By putting it in the SEC Act, you're only attracting unwanted attention. Unwanted attention.
But Mr. Cader, can I put it to you, don't you believe firmly so that Sri Lanka needs rules to prevent a repetition of the large-scale pumping and dumping that went on, where lots of small-time, perhaps under-informed investors were very susceptible and lost millions of rupees of their hard-earned money? So don't you think that we need an act which will enable easier identification and prosecution of the small number of culprits that have come and sort of infected our market?
Freezing of assets is not going to solve that problem for us. The one you're just mentioning is a greater problem, right? This is not a shortcut. This is not a shortcut to that problem. That problem has to be addressed with market conditions, right? So just freezing of assets, you're not going to sort out that problem. There's also another provision where the SEC has the power to go to courts and impose a travel ban. Now there again, that also for us can be done under the normal law of the land. Why do you need such powers in an act of the SEC? Because as I indicated earlier, you're only generating unwanted attention, and then you're also scaring the investors by doing so. But there are also a couple of other provisions that need to be addressed. One of the things is they're bringing in this provision of regulating unlisted securities. In the grand plan, regulating unlisted securities is something which needs to be done. But whether the SEC or we at this moment of time can regulate the unlisted securities is a question we have to ask ourselves. Are we ready? We have 280 plus listed companies that we are regulating right now. Are we going to extend that? Can we extend that in regulating more than 3,000 public companies? Do we have the skill? Do we have people whom we can get on the ground to work on this? Let us get our act together for us first on the listed securities, right? Let us do well on that, and then let us move towards the unlisted securities. The reason is regulating unlisted securities is a onerous task for us, right? There isn't a proper marketplace. There is no proper price discovery mechanism, right? How are you going to implement the insider dealing rules? How are you going to implement market manipulation rules, which are there in the Act? So we need to give more thought on these things before we embark. I think the Act, okay, go ahead, Faraz.
Mr. Cader, I hear what you say. The Republic hears what you say, but I put it to you. Surely Sri Lanka and our capital market will be a wholesome and a different place altogether if we had enough tools to ensure that those who have got the slightest notion of coming in and playing the system and trying to beat the system will be prosecuted, and prosecuted swiftly so that they won't do it again. After all, the Sri Lanka's market as it is now is almost a captive market for state funds, for funds investing the people's monies and so on, you know, the pension funds. So are you saying that we have enough regulations now, we don't need new regulations to control this? What exactly are you saying when it comes from that perspective?
For us, what this Act is bringing in is quite an amount of new regulation into the things, right? There are loads of good things coming in this new bill. I'm not for a while disputing those things. What I'm disputing is some of these provisions, right, that need better attention than this. This Act is a new Act, right? The regulations that were there in 1987 is not enough for us to go behind people now. So this Act provides those things. What I'm trying to highlight is I'm not trying to trash the entire Act down. No, that's not what I'm trying to do. What I'm trying to do is to highlight some of the provisions, right, that might not be that might not want to be done right now. This perhaps might not be the time.
But Mr. Cader, just ahead of a break that we're going into, can I ask you this? Are you not concerned that there are a minute number of rogues who are hell-bent on beating the system and breaking the rules, bending the rules even, and making money at the expense of the small-timers and at the expense of state funds like the EPF and ETF? As you know, in the past, those organizations have bought when the prices have been artificially driven up, and only to fall back to par levels, if you like, a couple of weeks later. There are the entire stock exchange is littered with such events. So on that point of view, aren't you happy, or should you not be happy that this new Act, the new proposed Act, will address some of those issues?
For us, this new Act addresses those issues. That's what I'm saying. I'm not trashing this Act. The market manipulation provisions have been expanded. Insider dealing provisions have been expanded, right? Credit to all those who have done that, right? Brought in new.
What about the appointment of the head of the SEC then?
Yes. Now, the appointment. We are moving into a very, very sensitive area for us, right? But nevertheless, since you brought it up, what I need to articulate at this moment of time is that when the amendments to the previous Act was brought in, it was brought in with the basis that the regulators the regulation, what you're regulating is the private sector. So you need to have a private sector oriented regulatory regime, a mindset of the private sector. That is why the appointment of the commission, it had stated that, I mean, the ratio is a 70 or maybe 60 to 40. 60 government, actually it is 70 because the president of the Institute of Chartered Accountants is also from the private sector. So you are having a 30-70 approach, right, in the regulatory regime. The commission will constitute 70% private sector and 30% government. And that is the balance. That's a good balance because you have the private sector mindset when you regulate. It is not 100% government. So that has been put in place. So, so that is why it says 6 people drawn from the private sector. 6 people drawn from the private sector, the minister shall appoint. There are certain qualifications they're asking for. So those are the 6 people basically who are appointed from the private sector. What you are trying to highlight is that number 6 person from private sector is not currently present in the current commission.
That's right. Why is that then?
No, so that is something the policy makers will have to take note of. Policy makers have to take note of.
But in the past, we've had people from the private sector, haven't we?
But people from the private sector.
Yes, in the past we have had people from the private sector.
Yes, yes. So, I mean, previously they had followed the rule that 6 people from the private sector are appointed.
So why is there a departure from that process now then?
Right. So that's the question we need to ask the policymakers. I might not have an answer for that, right? But if that has not been done in that particular matter as stated in the Act, there's something wrong.
I don't want to drag you into any more controversy than you ought to, but I'm telling you, and I put it to you, and I put it to the Republic, that the current head of the SEC does not fulfill those requirements because he comes from the, not from the private sector, but from the state sector. And that is why my concern, my concern is on that. On that note, actually, shall we go in for a short break and take a quick peek at this evening's headlines from Newsfirst's wonderful program, the Primetime News. We'll see you on the other side of the break.
Newsfirst Newsline with Faraz Shaukatali.
And welcome back to Newsline Zoom. Our guest this evening is Mr. Malik Cader, former Director General, Securities Exchange Commission. We're talking about the proposed new SEC Act. It's now a bill at the moment because it's going to be debated in Parliament soon. Mr. Cader has several questions, queries and concerns. Mr. Cader, what in particular, can you expand on some of these real concerns that you have about the new bill?
Yeah, Faraz, as I indicated to you, there are those things I mentioned, but they have also brought in a clause for civil remedies, where in addition to criminal sanctions, you could go behind people. SEC can do, individuals can go right and recover any loss or damage they have as a result of any market misconduct. They could go and recover them in a civil suit. And then, as you know, a civil suit is that you don't have to prove it beyond any reasonable doubt. Balance of probability is the test. So that is something which is good. So if someone has lost maybe 2-3 lakhs, right, you could go to courts and there is a remedy in that. SEC also can do that on your behalf. And then there is one other clause 148. The prosecutorial discretion has been vested upon the Attorney General. Now, that is something which is of concern. The reason is SEC does the investigation, and SEC, I think, should have the power to decide whether they are going to prosecute or not. They have basically, in this instance, passed it on to the Attorney General, not for any bad reason. I mean, there might be something good in that, but I think the SEC should be in a position to decide that, because anyway, the Attorney General will prosecute. Attorney General will be the attorney, right, on behalf of the SEC in any prosecution. So that decision should be taken by the Commission, because the Commission will have more technical know-how to decide whether there is an offence or not. So that is something which has shifted.
Mr. Cader, very quickly, should the regulator also be the judge and jury?
No. What happens is the regulator is not judging anything there. The regulator is not judging. There is the process within the Secretariat, basically, where you have gone through that process, right? There is surveillance, there is investigation, then there are committees, right? Before you come and you are telling the Commission, look here, this guy has done a market misconduct, right? And then the Commission must decide. Commission is that just one person. I mean, although there are 10 people in the Commission, there are people in the Secretariat, the Commission has to decide there is an offence. We have to go now and tell our legal counsel to file action and prosecute. That has been the process, and I personally feel that should be the process. Not that we take our files and go and ask the Attorney General, look here, is there a case for us to file? No. That should not be the case. So that is something, that is one aspect which is which needs attention. And the other thing is there are the 5 major offences for us which are there. This is a highly debated, and this can be argued, right, for a long time. That is, this current bill has taken out the provision of compounding. This bill has taken out the provision of compounding.
Isn't that a good thing?
Right? I might be holding a very bad brief in saying that you need compounding provisions in the Act. The reason why I'm saying that is we have a case which you have filed in 1996 is still awaiting judgment.
Isn't that
If this case was compounded in the year 2000, right, the matter would have ended there. He would have been fined. He would have paid a fine, and he would have gone. Are we trying to take all our corporates, right? Is this the intention of taking all the corporates to courts, right, and getting a finality there, right, and putting them in prison? No. They have to be hit hard. They have to be hit hard in the place where it hurts them the most. That is financially. Right? So you can compound the provisions, make things much more expeditious, and then end the matter with the SEC or at a low.
And do you firmly believe, or let me ask you another way, do you believe that there can be any kind of redress to the millions of small-time investors who lost money during the pumping and dumping, bearing in mind that one of the former previous SEC heads we had in the form of Mr. Tilak Karunaratne, who told us that there were 12 files, and then every 6 months later he came back and we never got to the bottom of those so-called 12 files. Only God probably knows what happened to those 12 files. And so does this new act provide any form of redress to such people who have not been able to get justice?
Yes, SEC can have civil. There are civil remedies that have been introduced into the act, right? So SEC can certainly file a civil case, right, and then basically get redress for the small-time investors. That provision has been.
What about, yes, What about, Mr. Cader? What about in the recent past we saw shares rise to huge levels with no apparent explanation? Will there be sufficient, handbrakes or emergency brakes put in place to stop shares soaring for no other reason other than perhaps somebody was trying to fix the market?
For us, we tried to do that in 2011, and you know what happened, right?
Yeah.
And I think, looking back now, I must tell you that it had been very successful, right? Looking back, turning back 10 years around the clock, right? Those handbrakes, those credit matters we brought into the market. Today, the market is fairly safe because there is no credit issue which is haunting the market. Brokers on the third day are after the investor to see that the money comes in. If you want credit, right, you can go to a margin provider and get your money, the credit you require to purchase securities. So from a credit point of view, the market is very safe. We looked very bad in 2011 for us. But now I must tell you, looking back, we feel very comfortable that we did the right thing. It's the same thing even with the handbrakes. It's the same thing with the handbrakes, right? We slammed that 10%. It worked. It worked, right? And the market was comfortable. But I don't think the perpetrators were happy or comfortable with what we did.
Well, some of those perpetrators are still at large, but Malik Cader, we've come to the end of this wonderful near half-hour program. Thank you very much, Malik Cader, for being on our program. Take care, have a great evening ahead of you, and as always, God bless you.
Newsfirst Newsline with Faraz.